Hey friends, Peggy Hall back here with you with a bonus. Peggy to the rescue. You can always find me over at thehealthyamerican.org. We are going to dive right into the Supreme Court ruling that came out today all about OSHA. And let me just say, it ain't over till it's over. If you are new to this channel, take a moment, subscribe, like, share. A big thank you to the moderators here at the Healthy American YouTube channel. I'm here every day, 3:30 p.m. Pacific, Monday through Thursday, often with a bonus episode on Friday. You can also catch me in the mornings, 10:30 a.m. That's 10:30 a.m. Pacific for the Healthy American morning to help you stay resilient and learn all about keeping your emotional wellness strong so you can fight this tyranny that's being and hogwash that's being sloshed all over us. The headlines are out. The verdict is in, but it's not really a verdict. Let me explain exactly what is going on at the Supreme Court, why this matters to you, and why I say it ain't over till it's over. Also, be sure to join me at the top of the hour, 4 p.m. We are going to have our VIP religious exemption special class for all of you VIP members only. If you don't have a penny to spend, don't spend a penny. Watch my religious exemption playlist with well over 100 videos. It's up to you to roll up your sleeves, educate yourself, learn about your rights, the laws that protect them, and then let me help you through that as well. So I'm going to bring up the Supreme Court ruling right here. And we actually, as you know, I don't rely on the headlines. We are going exactly to the Supreme Court. I'm not going to read what was on ABC News or NBC or any of that because I want to go to it's called the original source. So let's take a look now, shall we? And we are going to hop right on over to the Supreme Court ruling. And here we go. Per curiam means it is a ruling from the court. It is the opinion of the court. And here we go. These were the these were the companies that were bringing the lawsuit forward. It's only a 9-page document. We're going to talk about the most important points. And I want you to see if you can find the error that the Supreme Court makes. And I'm actually going to show you that error. And it's kind of astonishing to me. There's a couple of things that are astonishing to me. First of all, they're using the word mandate. All right, that's really ridiculous because it's not a mandate. It is a ruling. It's not a ruling, it's called a rule. It is a rule, it is a policy, it is a regulation. In fact, it's not even a regulation, it is an ETS, an emergency temporary standard. Those by nature are temporary, all right? The actual definition of a mandate comes from a court. For example, the court is actually mandating OSHA to stop. So that is the power of the court. I'm quite astonished that they have fallen hook, line, and sinker for this word. And I recommend that you don't use it, and you certainly don't use it at your company, and don't use it on social media, and please educate others to stop using it. Why not call it company policy, illegal measure, unlawful rule, whatever you want to call it, but for goodness sakes, stop giving power where power does not exist. So anyway, it says that, there's 84. Interestingly, it's not 80 million. I did a whole video all about the number 80. Okay, we know all about this, that OSHA created these emergency temporary standards that require companies that have 100 or more employees to create a COVID vaccination plan. Wow, I'm using all the words. I wonder if YouTube's going to find it on this algorithm. But what I'm doing is just talking about the Supreme Court ruling. So what it says is that, let's go a little bit into the background. All right. As soon as OSHA created that emergency temporary standard, which was back in November, right after that, many states and businesses and nonprofit organizations challenged OSHA's rule in courts of appeals across the country. The Fifth Circuit, this is a federal court, initially entered a stay. That means the Fifth Court, the judge there said that OSHA is out of bounds, and a stay means, okay, here we go. There are two parties to a dispute. OSHA said you have to do something, and the company said, oh, no, we don't. So that dispute goes to court. And while the arguments are and the evidence is being presented, time goes by. Sometimes a lot of time goes by because you have to have a court date, you have to have your witnesses, there are different motions from different parties. And so during the whole litigation process, the whole legal argument process, the plaintiffs, the ones that said, the businesses that said, hey, we're being harmed here, they asked the court to put a stay, to pause, to put an injunction, to tell OSHA to knock it off while all the litigation and arguments and evidence and all of that are carried out. And the Fifth Circuit said, yes, you're right. You probably are going to win. And because you probably are going to win, we're going to tell OSHA to back off, but we still have to go through the lawsuit. Are you following me? All right. So then the cases went before the Sixth Circuit Court, and the Sixth Circuit Court said, oh, no. We don't think that these plaintiffs actually are going to win, and we don't think that they're going to be irreparably harmed. So we rule that OSHA can carry on along its merry way of enforcing these measures and policies and emergency temporary standards. So that is what happened. So over the last few weeks, it's this, I told you it was a ping pong game. I'd go back and watch my videos all about OSHA. I told you it was a ping pong game. And I also said OSHA to the rescue, that OSHA is going to be the linchpin to pull down this whole ridiculous hogwash house of cards. So the ping pong game continues. And now the Sixth Circuit Court said, no, OSHA, continue on in your manner. So the company started scrambling again. And at the Healthy American, we started getting requests for people to learn about their rights. And I hope that you will join us over at thehealthyamerican.org. Click on religious exemptions. We've got free information. We've got programs where you can join us for small private group help and also one-on-one. We want to help you. So that was the second part of the issue. Then those that said, wait a minute, that's not fair. You can't allow OSHA to do that. We're going to take this to the Supreme Court. So that's exactly what they did. So stick with me. It's still in the Sixth Circuit. The lawsuit still has to be argued in the Sixth Circuit. Are you with me? This ruling of the Supreme Court is not final. It's part of the ping pong game. So it ain't over till it's over, and it ain't over. Yes, it is a step in the right direction, but it's not a final ruling. I'll give you the punchline first, and then we'll take a look at it. The Supreme Court said, wait a minute, we disagree with that Sixth Circuit, and we think the stay should be in place. We are ruling, our opinion is that OSHA needs to back off until the entire lawsuit is argued. Are you with me? I know you are. You're smart, you're savvy, you're learning. So the plaintiffs brought the lawsuit to the Fifth Circuit Court, and they said, you're right, the law is on your side. We're going to tell OSHA to knock it off until everything is settled. And then the Biden administration said, we don't like that. So we're going to take it to the Sixth Circuit Court. And the Sixth Circuit Court said, yeah, you're right. OSHA does have the right to do this. We're still going to do the lawsuit, but in the meantime, OSHA can carry on. And now the Supreme Court has said, no. OSHA doesn't have the authority to do this. And the lawsuit still has to be carried out. But in the meantime, pull back. How does that expression go? Hold your horses. And now the ping pong match today, as a recording of this video, says that OSHA has to halt. Yesterday, I did a video in advance of this, and it was called the Supreme Court and OSHA and what that means to you. And I explained, hope you'll go back and watch it. And I explained that regardless of the Supreme Court ruling, you still have religious rights. Nothing has changed in the law. And these ignorant, incompetent employers that are in way over their head when it comes to reviewing your religious exemptions, I would ask your HR department, what training have you had in Title VII? Because you don't know the law and I do. And these ignorant, incompetent completely inadequate employees are saying, well, the federal law is changing quickly. Excuse me? No, the federal law hasn't changed at all. The federal law is called Title VII. It has not changed since 1964. So let's continue, shall we? And we'll take a look. So it says that the applicants, right, the plaintiffs are now seeking emergency relief. It's another injunction. It's another stay saying that OSHA's measure exceeds its statutory authority. That means the authority that it was given to them by Congress, and that it is otherwise unlawful. The Supreme Court agrees that their lawsuit probably is going to win. And so they said, we're going to put the pause on while the lawsuit is still being argued. I've not even seen any reporters on because I don't watch it, but ABC, NBC, Fox News, they're not even talking about this. They're talking as if this is a done deal. You're smarter now because you're watching The Healthy American, Peggy to the rescue. And the rest of this lawsuit, or the rest of the ruling here, talks about the OSHA being created in 1970. And this is such a good point that the Supreme Court makes, that OSHA has the authority to ensure occupational safety. That means safe and healthful working conditions. It does not have the authority to regulate public health. That is what the Supreme Court said in this order. And then the OSHA Act, the Occupational Safety and Health Administration Act, does say that OSHA can create an emergency, emergency temporary standards. There are two reasons why they can do it. Number one, if there is a grave danger, here we go, from exposure to substances or agents determined to be toxic or physically harmful. Well, friends, I looked up the word substance, and substance, you have to be able to see it. It has to be evident. It has to be visible. An agent is also a substance that can be biological or infectious. The issue with the cooties, as I call it, is it's never been seen. That's right. That's right. I actually had the sniffles over the holidays, right? I had the sniffles. That's what I had. You had a little, I feel great now. Yeah, a little honey lime with the, a little soup, a little rest. Yeah, I got over that cold in a few days. So the second way that OSHA can create an emergency temporary standard is if it is necessary to protect the employees from such danger. Now, for the next several pages, this order goes on to say that it's not necessary, that there are other means of protecting the employees. But the most important thing is that it says, actually, here's the mistake that the Supreme Court made. It said that the Secretary of Labor, who oversees OSHA is part of the Department of Labor. It promised the emergency standard. It says there are narrow exemptions for employees who work 100% of the time, but those exemptions are largely illusory, meaning it's just a bunch of hogwash. And I agree, but I read that it said there were no other exemptions. That, let me see if I can find that. If not, I will link to it, or I'll do a follow-up video. But it did say that there were, and you see, that's not true. There are exemptions. There are medical exemptions, and there are religious exemptions, and that is a part of Title VII of the U.S. Civil Rights Act. So here we go. It's giving a little bit more of the background that once OSHA published its illegal measure on November 5th, people started to file, and the cases were consolidated in the Sixth Circuit. But prior to that, the Fifth Circuit said OSHA should stop. Then the Sixth Circuit said OSHA can continue. All right, that's what it's saying here. Okay, let's go on. Various parties, after the Sixth Circuit said, oh no, OSHA has the right to do this, then other parties filed with the Supreme Court saying, we want you to review the ruling of the Sixth Circuit because we are being discriminated against here. And here we are. The Sixth Circuit concluded that a stay of the rule was not justified, that OSHA had the right to continue. And the Supreme Court says, we disagree. And then they go on to say, we believe that they're likely to succeed. This argument from the plaintiffs is a good argument. And I also like this. This is very important. Administrative agencies like OSHA are creatures of statute. That means law. They accordingly possess only the authority that Congress has provided, period. They are not a law-making body, and they can only promulgate or create regulations or emergency temporary standards that do not violate the law. There are so many laws being violated here, it's not even funny. The Fourth Amendment, for example, sovereignty over your own body, your property, your body is your property. So let's go on. I want to get to the good part here, and here we go. OSHA says that they have the right to do it, and the Supreme Court says it does not. The act, the OSHA Act, gives OSHA the power to set workplace safety standards, not broad public health measures. Thank you, Supreme Court. You got it completely right there. And then it says, let's go on a little bit more. You can read this. I will have it linked for you. But the most important thing I want to show you is, I love this. It says that although cooties, let me just say the common cold, is a risk that occurs in many workplaces, it is not an occupational hazard, because they're saying that it happens everywhere, at home, in schools, during sporting events, and everywhere else that people gather. Now, I could have a whole nother video about, because I don't really talk about science and medicine on this show, but many of you smart, savvy, supportive, healthy Americans know the score. You know all about the theories that they are referencing here, because the fact of the matter is how people get sick. I had to say that under my breath. So I think you can read between the lines. That kind of universal risk is no different from the day-to-day dangers that all of us face from crime, air pollution, or any number of communicable diseases. So it just says, just because it can happen anywhere doesn't mean that OSHA has the right to regulate it. I thought that was wonderful. And then it says this, of course, the needle cannot be undone at the end of the workday. So that is quite a bit different than saying you have to wear steel-toed boots. I mean, that's fine. It doesn't have anything to do with your health of your body, the functioning of your immune system. And so here we go. It says that in certain cases, they probably could regulate it if somebody's working, you know, in a science, if they're, for example, if they're working in a crowded or cramped environment, or they're researchers that are working with the cooties, possibly OSHA could have that. But in general, it is not viable and it is not legal. So let's get to the bottom line. It says that we are told by the states and the employers that this measure will force them to incur billions of dollars in unrecoverable compliance costs and will leave hundreds of thousands of employees, will cause hundreds of thousands of employees to leave their jobs, which is happening. And I like that it says cause, because they're being fired. And I want to help you avoid being fired. Watch all my videos on this channel. If you have questions, I've answered them already. You've got to educate yourself, friends. And then it says, but the federal government says that these measures will save over 6,500 lives and prevent hundreds of thousands of hospitalizations. And the Supreme Court says it's not our role to weigh the trade-offs. In our system of government, that is the responsibility of the Congress, of the legislative branch of government. So buckle up, friends, because they are going to be introducing legislation. I believe that they will, now that the Supreme Court said OSHA can't do it. So you've got to make sure that you have your eagle eye on that. Although Congress has indisputably given OSHA the power to regulate occupational dangers. It has not given that agency the power to regulate public health more broadly. So it says that the application for the stay, you know what that means now, presented to Justice Kavanaugh and by him referred to the court are granted, which means the OSHA's ETS has no ability for legal enforcement until the United States, the Federal Court of Appeals for the Sixth Circuit, has completed its litigation. So that is the order of this court. Friends, I have got to hop on my VIP call for the religious exemptions program. I would love to have you join me over there at thehealthyamerican.org. You can still sign up. You get my personal help if you need that. And you get to also connect with other freedom fighting folks. You're going to click on religious exemptions, click on the concierge and VIP programs. I hope you're going to join me in the VIP. If not, you can watch the free video here. And we also have a class about how to sue your employer if you're interested in that. My goal is to bring you all of the information that you need. Pastor David and I are here with you every step of the way. I will be back with you tomorrow. I'm going to be bringing on another attorney talking about suing these Board of Health, right? Having these, not really suing, but going to these administrative hearings when the Los Angeles Department of Health has told a business to close because they're not enforcing the self-suffocation devices. I am in on that case. I am assisting where I can. I want to bring you all of the information. You're going to meet the lawyer that is going to bat. And friends, I can't wait to see you in the very next video. Thank you, everybody. Big shout out to all of my moderators. I will do a follow-up video with a Q&A all about the Supreme Court order today. I did read in there that they said there were no exemptions, and there are exemptions. I did a whole class all about OSHA. OSHA to the rescue. Watch that as well in terms of the free live streams. And let me know. Let me know that you are fighting for freedom. It's not just freedom, my friends. You're fighting for your soul, and I'm going to be with you every